This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about a multi-unit construction exclusion in a CGL that effectively eliminates coverage and why a magistrate's report to a U.S. District Judge was affirmed because the exclusion clearly and unambiguously defeated a claim for defense or indemnity from non-parties. Midvale Indemnity Company sued Arevalos Construction, Victor Zuniga, 625 Halsey LLC, and others, seeking a declaratory judgment relating to a commercial general liability insurance policy Midvale issued to Arevalos and an underlying lawsuit in New York State court captioned Victor Siguenza Zuniga versus 625 Halsey LLC et al., the underlying action. In Midvale Indemnity versus Arevalos, the U.S. District Court for the Eastern District of New York on July 5, 2023, responded to a request to overturn the report and recommendations of the Magistrate Judge to acknowledge the default and order no coverage for defense or indemnity to anyone named in the underlying action. D&G and Zuniga timely objected to the report of the magistrate. Those objections required and triggered the U.S. District Judge's de novo review. D&G, a subcontractor of Arevalos, claiming coverage and a right to indemnification by Arevalos insurer Midvale, and Zuniga, the injured tort claimant in the underlying action, have been named as defendants in this declaratory action by Midvale. D&G and Zuniga objected to the magistrate's finding that none of the named defendants was owed coverage under the policy. The district judge, in reaching his decision, found that D&G and Zuniga objected to the conclusion that they lacked standing to oppose Midvale's motion, its finding that none of the named defendants were entitled to coverage, and the scope of its declaratory relief. The magistrate recommended finding that D&G's subcontractor agreement with Arevalos imposed no duty on Midvale, a stranger to the contract. To D&G, he also found that D&G does not claim to be a third-party beneficiary of the policy, that the policy does not indicate an intent to confer a benefit upon D&G or any other individual or entity other than Arevalos, and that Zuniga is not a named insured or a third-party beneficiary under the policy. In New York, a non-party to a contract generally lacks standing to enforce the agreement in the absence of terms that clearly evidence an intent to permit enforcement by the third party in question, unless it establishes, 1, the existence of a valid and binding contract between other parties, 2, that the contract was intended for his benefit, and 3, that the benefit to him is sufficiently immediate rather than incidental to indicate the assumption by the contracting parties of a duty to compensate him if the benefit is lost. The U.S. District Judge concluded that the magistrate did not err. He found that Arevalos was not entitled to coverage because of the policy's multi-unit and tract housing residential exclusion, which excluded coverage for bodily injury arising out of any construction operations that involve a housing tract or a multi-unit residential building. Since the underlying action seeks damages for a construction project falling under the exclusion, specifically one for a 4-story building with 10 residential units, the exclusion clearly applied. The scope of relief is proper because it is what Midvale requested in its complaint, and because the magistrates rightly found Midvale is entitled to a default judgment. The court adopted the relief recommended by the magistrate, but noted that it is only binding upon the defaulting parties. The court overruled D&G and Zuniga's objections, adopted the magistrate's recommendations, and directed the clerk to enter a judgment granting Midvale's motion for a default judgment against Arevalos and RM, and declaring that Midvale has no duty to defend or indemnify any party with respect to the underlying action. In my opinion, every defendant in a lawsuit wants it resolved with other people's money, and even if they did not buy insurance to protect themselves, will seek the benefits of insurance available to others. Claiming a benefit to an insurance contract as a result of a construction contract can often be effective if the policy provided coverage. In this case, there was no coverage because of a clear and unambiguous exclusion. The insurer had no obligation to provide defense or indemnity to anyone. And the parties who didn't get coverage were not parties to the contract and were not made additional insureds. It pays for a party seeking insurance coverage to actually read the insurance policy before making a claim and filing a suit. This video was adapted from my blog Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog and you will receive notice of at least 5, sometimes 6 blog postings a week, and access to the more than 4,550 blog postings. If you find this video to be useful or interesting, please click on the like button or the thumbs up button at rumble.com, and please tell your friends and colleagues about this blog and the videos, and let them also subscribe to the blog and or the videos. If you're interested in more detail about insurance, insurance law, insurance claims, and insurance fraud, please consider subscribing for a very small fee to my Substack publications or my locals community. Thank you for your attention.